please, my lords.
Have we been called on? Was I not listening?
We have.
We have. So sorry.
Not so.
Yes.
Please, I appear on behalf of Jennifer Cuthbert, who is the widow of Derek Cuthbert, who I've explained will be referred to as the deceased
Yes,
throughout
of
these
course.
proceedings without any disrespect being intended to his memory. And I appear together with London Mr. Archer and Ms. Franklin. The respondents to the Cuthbert appeal are represented by Lundgren, Mr. Kent, King's Counsel, and behind him Ms. Foster. There is, of course, the second appeal of White, where the appellants are represented by Mr. Steinberg, King's Counsel, leading Mr. Murray, who sits behind him, and the respondents in that appeal are Mr. Platt, King's Counsel, and Mr. Turton. Lundgren, Mr. Turton sits behind him. My lords will be aware that these cases were tried separately, with the case of Cuthbert being heard before His Honour Judge Freedman, sitting as a judge of the High Court, on the 31st of October to the 1st of November.
Mr. Rawlinson, I'm getting elderly, and if you could speak up slightly.
Oh, I'm so sorry. It's usually not a matter of complaint that judges can't hear me. The case of Cuthbert was heard the last day of October, the 1st of November last year. The case of White was heard by Mr. Jeremy Hyam, King's Counsel, sitting again as a judge of this court on the 3rd of November last year. Judgment in Cuthbert was handed down on the 3rd of November as well, and that in White of the 2nd of December. My lord, in both cases, damages were sought for personal injury on the basis that the victims had developed mesothelioma, to which it was said asbestos exposure during the course of their employment had made a material contribution. And in both cases, the exposures took place before the watershed date of mid-1965, or late 1965. And by that, of course, I know that this court will be aware that the watershed refers to the newly promulgated knowledge at that stage that even very low levels of exposure to asbestos dust could cause a form of cancer called mesothelioma. It is accepted by the two appellants in these cases that the risk foreseeable at the time of their exposure, this being in the 1950s and pre-watershed, was therefore not that of mesothelioma, but rather that of asbestosis and of the associated complications that can arise therefrom. And my lords may have picked up from the literature already that at the time tuberculosis and susceptibility to other unrelated infections such as pneumonia were considered to be one of those complications. But at the time that asbestosis was the only disease foreseeable, it was understood, clearly understood from the literature, that it was itself capable of being a fatal condition either directly or indirectly. In both cases, of course, the claims were dismissed, and they were dismissed on the grounds that the exposure proven at the end of the evidence was insufficient to have given rise to a foreseeable risk of injury. My lords, we should be clear at the outset that both appellants accept that there is a level of exposure which would not give rise, or would not have given rise, to a foreseeable risk of injury at the time. But both appellants assert that in their individual cases, the exposure that they face lay above that level. In the case of Cuthbert alone, we will submit this morning, as Malone for Mr. Archer submitted at trial, that given the inability to measure the degree to which dust exposure was taking place during the relevant period, and in the absence of guidance, official or unofficial, the trigger for acting was knowledge that the work under consideration led to clouds of visible dust being created. And in this sense, we will submit that the exposure in Mr. Cuthbert's case, the deceased case, was substantial even on the learned judge's findings below. And of course, in neither case is it suggested that the defendants took positive steps to reduce the exposure that did in fact occur. The order of the single Lord Justice William Davis, made on the 5th of June 2023, required both these appeals to be heard together. Clearly, there is a high degree of overlap between the two of them, but they are, of course, run as separate appeals. And whilst I'll open the facts on the case of Cuthbert, of course, I will leave it to my learned friend Mr. Steinberg to open in respect of White. So this leads to two additional issues of housekeeping. One is timetabling and the other is bundles. In terms of timetabling, the parties have agreed, subject to the court's direction, that I shall sit down by lunch, and then Mr. Kent will take the rest of the day in his response. There will then be the opening from Mr. Steinberg tomorrow morning in respect of White, response from the learned friend Mr. Platt, and then perhaps 15 minutes at the end for Mr. Steinberg and I, if it's necessary, and of assistance.
Yes, thank you. I mean, the sequence is fine. The timings, your timing as the person opening it, I think you'll need all that time, and there's no problem about that. Generally, one wouldn't expect the defendant to need, respondent, I should say, to need as much time. And in the second case, although of course the facts are different, a lot of the legal ground will have been covered. So we are a little bit, well, how do we put it? Well, optimistic that it will not necessarily occupy the whole of the second day. But let's see how we go.
Yes.
And we may not run right up to 4:30 both days, but again, we'll see how we go.
So this, of course, we will be guided by direction. In terms of bundling, there are a number of bundles between the two appeals that carry different titles, and it may assist just for me to list what is before the court, at least in our expectation. The respondents recently in White have had permission to file a core literature bundle and a reference literature bundle.
Yes.
Their core literature bundle replicated much of what was contained in the Cuthbert supplementary bundle number 2.
Yes.
And so the agreed hierarchy is as follows. There are separate core bundles in the usual form, with usual content, for Cuthbert and White
Yes.
separately. In Cuthbert, there is supplementary bundle 1, which contains transcripts of evidence, occupational hygiene reports, witness evidence, etc. I understand that the equivalent to that in White is simply the supplementary appeal bundle.
Yes.
The background literature documents pertinent to Cuthbert are contained in supplementary bundle number 2, the engineering documents.
Well, perhaps we can cut this slightly short.
I'm sorry.
You have the good fortune as you're starting to refer to whichever bundle you find most convenient or most familiar with. Once you have referred to a piece of literature in the bundle you prefer, which is no doubt the one from your side, your case, we would be grateful if Mr. Steinberg and the parties in the other case would swallow their pride and refer to it in that one as well.
Yes.
Because we'll want to mark up only one.
Yes.
But we don't mind which we're referred to, as long as we're not referred to the same document in two different bundles at different stages of the case.
And so I understand the parties have arranged themselves.
Good. Okay.
And then finally, there ought to be 3 consolidated authority bundles.
Yes. Which have been well put together, and we're grateful to whoever did that.
Yes, well, not me. So the thanks will be, I've no doubt, accepted in the right quarter. My lords, therefore, to deal with Cuthbert now, moving forward, I intend...
Can I raise a couple of
Yes, of course,
little tiny pieces of housekeeping? One for Mr. Platt and one for Mr. Kent, but to give advance notice. Paragraph 70 of Mr. Platt's skeleton, you don't need to look it up, refers to the limits as referred to in successive versions of the toxic substances on pages 157, 218, 288 and 291. Those are all in the skeleton. At some stage, if only for my benefit, could we be given an agreed synchronization of those as to what the different numbers mean?
Yes.
And where the change comes. I think it's 1965. Yes. The second thing, in paragraph 10 of Mr. Kent's skeleton, could we have a reference? But that's this afternoon.
I will, thank you.
Thank you. So,
Off you go, Mr. Robertson.
I'm very much obliged. We would seek to approach this in 4 stages. The first is to set out relatively briefly the pertinent facts in the approach taken by the learned judge below. We will identify an outline only in outline where we respectfully submit error is to be found. Stage 2 will be a review of the literature insofar as it is necessary. Stage 3, a review of the law, because we will respectfully submit that this is a slightly peculiar area, albeit under the umbrella of negligence, where the courts have helpfully given guidance as to what the meaning of certain documents is taken to be. And then fourth, to return to the judgment and to make good in a few short sentences, again, where we say the errors truly bite.
That's fine. What was your second heading?
Was the literature.
Yeah, thank you.
Perhaps may I paraphrase generally in this respect before I launch, and it's this. I know, of course, the court will have been able to do some pre-reading. What I would propose is only to take the court to reading documents on my feet, where we respectfully feel that it's absolutely necessary to do so. Otherwise, I will give references as we go along. But of course, if there is anything that catches the panel's eye as we go along, then I will immediately take it to the
Thank you. That seems entirely sensible. And as you say, we have done a fair amount of pre-reading, but that doesn't mean that for important documents we wouldn't have to read them again in court. So no problem at all.
I'm grateful, my lord. So we commence with the core facts, and the deceased was born on the 14th of December 1938 and died from mesothelioma on the 5th of April 2022, aged 84 years and following a period of 15 months of ever-increasing symptoms and debility. He'd left school, as was the norm at that stage, in 1952, aged 14, and had been in the workforce for 3 years when he came into the employment of Taylor Woodrow in 1956. And he alleged that he remained there in employment till 1959. And during the entire period of that employment, he said that he was employed as a trainee supervisor and that he was put to work at the Queenswood School in Cheshire, and his exposure to asbestos occurred therein. He alleged that he had been supervising carpenters who were themselves cutting asbestos insulation board. He named the make of board as being Asbestologs. My lords, by way of background, those were sheets sold by Cape and were known to contain amazite, which is a finding of fact that the court makes below. Amazite being a well-known promoter of mesothelioma. They were cutting those boards in the construction of internal lean-to, soffits, linings and canopies. He said that he saw them daily and would be standing just a few feet from them as they cut their boards, either by mechanical methods or by power tools. He couldn't quite remember which. He said that cutting took place both indoors and out, and he was frankly inconsistent as to whether the indoor cutting took place in the basement or the ground floor, as between the 2 witness statements that he had provided. My lords, the pertinent paragraphs for your note are page 275 of the first volume supplementary bundles, and 276, both paragraph 3.
So these are witness statement references.
These are witness statement references.
275.
Paragraphs 3 and 4, they travel over to page 276. And within his first witness statement, at page 266, paragraph 7. Those are where all these references that I'm about to refer to will be found. He set out that on occasions he had carried out cutting himself whilst demonstrating to the men that he was training to supervise. And then perhaps of central importance, so far as we are concerned, he was required to dry sweep detritus, which included the remnants of the boards that had been sawn, and therefore of necessity containing asbestos dust. He recalled that the cutting of the boards created visible clouds of dust, and that cutting was undertaken for between 1 to 2 hours each day. The sweeping was undertaken by him, and it was undertaken after the cutting had occurred, and he would undertake the same several times a day. Forgive me. And he was given no respiratory equipment or training. My lords, by way of overview, the occupational health experts that were instructed by each party approached the assessment by which they sought to set out the degree to which this evidence, if accepted on its face, led to exposure in different ways. Ms. Conroy, on behalf of the claimant, did so by reference to maximum exposure levels. Dr. Phillips did so by reference to average amounts. By their separate methods, they came to separate conclusions. Ms. Conroy concluded that particularly when sweeping, there would be exposure up to 100 fibres per millilitre of air. Whereas Dr. Phillips considered that the daily average would be somewhere between 1 to 2 fibres per millilitre of air.
So what was the Phillips figure?
1 to 2. And indeed, as an average, Ms. Conroy did not disagree.
That was on the basis of an hour and a half to 2 hours exposure a day.
Yes, yes. And the point was taken perfectly properly that the exposure could be cut down by reference to the times that he was not exposed to asbestos. But forgive me, the 1 to 2 fibres per millilitre was the overall exposure on the evidence in terms of sporadic exposure, but over that period of 1 to 2 hours a day, yes. Both experts were, of course, cross-examined, and I'm going to deal with 8 very swift points where we say that significant concessions were made by Dr. Phillips, and at the end of each one, I'll give the reference. But the general overall reference is that it's in the Cuthbert supplementary bundle, divider 1, and thereafter I'll simply give the page numbers. Insofar as the claim involved the deceased sweeping and carrying out his own sawing, then it was not fair to refer to this as a secondary only claim, secondary exposure only claim. It was one where he was himself directly engaged in working with asbestos.
So this isn't one of your 8 points, or is it?
It is, yes.
It is, that's your first one?
It is, and that's
Okay.
page 51, letter C.
What was the reference?
Page 51, capital C, my lord, please.
Okay.
And that's divider 1 of the supplementary bundle 1.
And you'd like us to go to that, yeah?
No, I'm simply happy to summarise and to give the references rather than.
But maybe my lords will want to, but okay, so as long as you're not.
I just want to check the first one, just so that I understand the system.
Yes, of course. Well,
51C, secondary in nature. Yeah. One thing that you do, Dr. Phillips, is you describe Mr. Cuthbert's exposure as being secondary in nature. That's what you're referring
yes.
to? Good. Thanks.
And he said that is not secondary exposure. Yes. And again, of course, I will stop as soon as it assists the court. But there being a lot of material to go through, I won't unless asked. The second proposition that he accepted was that Ms. Conroy's assessment that sweeping could create exposure up to 100 fibres per millilitre of air was, he thought, on the high side, but not out with the values that he would have accepted. And the reference to that is page 51, E to F.
I'm so sorry. Which E to F?
Page 51, my lord.
Okay, thank you. These are not in your service.
No, these are simply
The references to back up the points.
indeed, yes, they're explanatory. The next one I will take because it's in a slightly odd form. The court too. If we could turn, please, to page 52G. there was a passage of arms between Mr. Archer and Dr. Phillips about subjective impressions of how heavy the exposure to asbestos was. And at the bottom of the page, His Honour Judge Freeman, letter G, said this. Well, I'm cutting through this, Mr. Archer. Dr. Phillips will not be departing from what he said. Having said we should focus only on his second report, I'm afraid I've marked it in the first report, but what he says is that the job included sweeping up. Quotes, the deceased says his job was cleaning up, sweeping up after the carpenters, and this led to high asbestos dust concentrations, which inevitably would have if they'd worked with asbestos board. Answer, yes. Question, I don't imagine you depart from that. Answer, yes, I do. And I draw this to the attention of the court because on the page it looks like he's flatly contradicting what is being put to him. But I'm assured that the impression for those in court was that he was saying, yes, I'm sticking with it. And that would seem to be consistent with the fact that nobody then follows up saying, well, why have you changed your mind? And so what is on the page may be a slightly misleading guide to what in fact was the substantive answer. And it's for that reason that I've delayed the court by taking you to the reference itself. But we say that he accepted that sweeping did give rise to high dust concentrations. And again, he said this, that the deceased description of clouds of dust arising when asbestos boards are being cut, and the fact that this contaminated his clothing was evidence of, quotes, very significant exposure to asbestos, and that within his average figures, the 1 to 2 fibre mils that I've already presented to the court, respecting exposure, there lay, quotes, periods of high dust concentrations, periods of high exposure to high dust concentrations for a limited period of time. And my references to that, my lords, are page 53G, and thereafter page 54D to E. The fifth concession.
Hang on 1 second.
I'm so sorry.
What was the references? 53G.
Sorry, 53G and then 54D to E.
And the point is that the averages included periods of much higher concentration as a result of sweeping.
Yes, and cutting.
The transcript obviously has a weakness, which is punctuated by inaudibles,
Yes.
but I think one can see the gist of what's being said.
Yes, so I would submit. Can I say at once as well that there is, we accept, a distinction to be made between the sorts of levels of exposure that one would encompass, or one would experience, I should say, if one was soaring, as opposed to being a bystander. And we don't have any adverse comment to make that the judge proceeded on the basis that as a bystander to others cutting, even a few feet away, there would be something like 10% of the exposure compared to the person being cut. It's effectively a well-known variation of the inverse square law in terms of the density of exposure.
So the weight, and this is already coming out, was already come out from the Australians, and it's coming out from these points. The weight of your case is based on those episodes where he was more than a bystander.
That is the weight, but that is only in terms of ensuring that the court is satisfied that he did indeed have quite a substantial exposure. And therefore the conclusion that it was light and intermittent cannot be upheld. But in terms of foreseeability, all of the exposures are, in our respectful submission, significant because they create clouds of dust. And so there are two separate steps to be considered. The first is the dose that this individual received, and the second is the flag raised by the work being undertaken, which then leads to the dose. And so we say that even for bystander exposure, although his dose may not have been anything like the same as the man who was cutting, it still creates visible clouds of dust, and from that, foreseeability springs.
Was there evidence, quantitative evidence, which obviously would be based on more modern assessment, of the likely level of inhalation dose for the person actually sawing up?
There are such documents.
I know there are, but were they in evidence before?
Yes, they were. But one is referred to as EH35, which is a publicly available document promulgated by the Factory Inspectorate, where they carried out precisely these sorts of exercises. There was also...
Can you remind me when?
yes, I can turn my back and find out where EH35
Well,
is.
sometime.
It's in the judgment as well,
It is.
I think.
It is.
Para 14.
Well, I'm very much obliged to my own friend. It's...
Sorry.
39 of
Sorry, Kate.
the 39 in the engineering.
I'm told it's page 39 in the engineering bundle.
Sorry, not.
We will find the full reference, I promise, my lord. Of course, there was also the Red Road document that was put forward in evidence below. But the difficulty with the Red Road document is that it is more descriptive than it is quantitative. But really,
Of when it was made, wasn't it?
Indeed. And so one always approaches these subsequent documents like EH35 with a certain degree of care. The laws of physics don't change. A board cut is still a board cut whenever it was cut in terms of the amount of dust it produces. But what was known about that at the time, of course, travels differently, dependent upon when the ability to measure is undertaken and when documents like this are in fact promulgated. The fifth concession made is that there were no methods of measuring dust at the time of the exposure and no guidance or applicable thresholds. And the reference to that is at page 57 of the transcript, divider 1, letters E to H.
Again, sorry, and what, just repeat what the concession was. No methods.
Of measuring the dust.
Yeah.
And no guidance or applicable thresholds. He was then, this is the sixth area, asked by Mr. Archer about the Merriweather and Price document, which of course we will turn to very shortly, and asked to accept the proposition that the only thing that is clear is that reducing exposure reduces the risk of permanent pulmonary injury. At that stage, that's 1930, he agreed with that proposition, and the place that we find that is page 60, letter D. Crucially, given the stance that the respondents take in this appeal, he also agreed with the proposition that Merriweather and Price did not provide comfort in respect of exposure less than those properly to be described as heavily and prolongedly exposed.
They simply didn't address it.
Well, the learned judge didn't, but
As a concession goes, it's not much because Merriweather and Price just simply didn't address that question.
they did.
Unless you say they did, in which case I've missed it.
Well, we'll go to the document, of course, but my lord, the document effectively says two things. The first is that we won't know what sort of protections are actually required until we know what the health effect of lower exposures is. And second, it points out that there is little comfort to be derived from the obverse of what it does find, which is heavy exposure leads to asbestosis. The document shows us that the obverse is not necessarily true, that there is no risk from low exposures.
You take us to the
I
document.
will do. Really, I can do it now, but
No,
but just
whatever
to keep the course on, but I promise I will. And of course, we did have the two follow-up documents from Dr. Merriweather in 1931 and 1933 that make that all very clear beyond peradventure. The heavy and prolonged reference is to be found at page 61G2, forgive me, page 61G. And he immediately thereafter at 61H accepted the proposition that no employer would have been able to safely assume that Mr. Cuthbert's activities would not have resulted in the condition.
Is this 6 or 7 still?
This is 61H.
No, whichever your
Oh,
points.
6. I'm so sorry.
These are
Point
variants
six.
of point
Still on
6.
6.
Point 6.
61D and
61G to 61H.
my hearing is worse than my lord's.
No, not at all. I will keep shouting. At page 64G to H, he accepted that a construction industry body like Taylor Woodrow ought to have paid attention to guidance and publications provided by the HMFI. And finally, at 66E, this is the 8th point.
Hang
he
on.
can-
Well, hang on.
I'm so sorry.
What was the reference for 7?
Was 64G to H.
Thank you. And then right, I've now caught up. 8.
Is that, and this is at 66E, that the overwhelmingly clear message would have emerged had this defendant made inquiries and had these documents been brought to their attention, that dust overall was hazardous and ought to be suppressed. That was the remedy.
That, did you say at 66E?
Capital E, please.
I don't disagree, but well, I don't remember to see that. Oh, sorry, yes. Okay, 66D I got it as, but yep, that's fine.
Yeah. Thank you. So to turn from those concessions to the judge's judgment, he made a series of findings regarding the circumstances of the exposure. At paragraph 32, he roundly rejected the assertion that the deceased was a trainee supervisor.
Great, again, I'm all for your being speaking. I'm not trying to slow you up, but I haven't. I just would like to look at the judgment while you're
Yes,
making these points. Sorry, paragraph, which did you say?
32.
Yes.
He said as follows: I agree with Miss Foster that it is highly debatable whether the deceased was employed in a supervisory capacity, even as a trainee supervisor. It seems to me to be much more likely that, given his age and singular lack of experience, his true job description was that of general labourer. If I can then try to summarise paragraphs 34, 35, 36 and 39, and they appear at pages 68 to 69,
So, sorry, 34.
35,
Yeah,
36 and 39.
yeah.
He found that carpenters would not have been cutting asbestos board every day for the entirety of the 3 years of the deceased's employment. That the deceased might have seen carpenters on a daily basis, but he would have seen them only sporadically, not amounting to 1 to 2 hours per day. And that the deceased would have kept his distance from any clouds of dust. However, prior to this, at paragraph 21, on page 65, he had found that those boards that were being cut were asbestos boards.
Well, that wasn't in dispute, was it?
Yes, it was, because
I thought the dispute was as to the type of asbestos board.
yes, but I'm so sorry. I was forgetting. Boards tend to import asbestos insulation board of the asbestos type. Usually, asbestos cement are referred to as sheets, but that is not something that would be obvious
Oh,
to
I
the
see.
reader.
So, all right. But your point is that he accepts that it was asbestolux.
Yes. I should have made that clear. I'm sorry. He also then found, having found that these were asbestos boards, at paragraph 37, back on page 68 again, that he would have swept on occasions a number of times per day. And it may be worth my just reading paragraph 37 because it contains something that we will make complaint about at the end. He said this, that as to sweeping up, I'm willing to accept that this was a task which the deceased undertook from time to time, and maybe on occasions a number of times per day. What I'm unable to accept is that he was the person who always swept up after the carpenters once they had cut up the asbestos materials. Experience would suggest that they probably did some of their own sweeping. Furthermore, whatever his job description, it's difficult to understand how or why he would have been allocated the specific task of sweeping up once the carpenters had cut the asbestos material. Further, in any event, the sweeping up undertaken by the deceased will have involved not only asbestos dust, but other types of dust. And at the end of these submissions, we will invite the court to say that actually there was really no evidential basis for these findings at all, beyond saying that he would have swept up to a number of times per day. The claimant's, forgive me, the deceased's witness evidence was clear and was effectively uncontroverted by any evidence in opposition.
Sorry, can I just be clear? Which bit do you say is the judge shouldn't have found? What's the punchline on that?
The punchline is that there were others who would have been doing their own sweeping. Also, that his doubt about whether the deceased would have been the man allocated to do the sweeping.
That's really two ways of making the same point.
It is, yeah. And if I can continue then on to the next paragraph at 38. He said this, that the deceased himself does not give any information as to over what period of time on each working day he spent sweeping up dust. Even if I were to conclude that he did do sweeping up on a fairly regular basis, it seems to me probable that this would have only occupied a very small portion of his working day. Indeed, I would not disagree with the suggestion made by Miss Foster that perhaps he spent in the order of 10 minutes per day sweeping up.
You challenge that?
Well, my lord, we simply note that there is no evidence to support a specific finding of 10 minutes a day. But what we say is that it doesn't actually change matters, because what the judge doesn't do is take into account that even if it was a minute a day, or 2 minutes a day, or 5 minutes a day, it would have involved intense exposure to asbestos dust that would also have created visible clouds, and that was the signal, amongst others, that should have led these.
You've many times made the point about would have created visible clouds. Where will we get that from? We'll come into that later.
Yes, well, my lord, the evidence will be that, or the evidence is, that cutting boards creates visible clouds. And
Well, that I
Yeah.
intuitively can understand, and maybe it doesn't matter, I intuitively understand is what the evidence says. But is there evidence that sweeping up debris from detritus, I think was your word, from the floor, which includes any asbestos dust that would have fallen there from the cutting earlier in the day, would create visible clouds of dust?
yes,
Okay.
so TDN 35, which is the document entered into evidence by my learned friend
Well,
Mr. Platt.
you're being very systematic, that's fine. If the answer is yes, there is evidence, and it's in TDN 35, fine, we'll get there.
There's a photograph that shows it.
Yeah.
The judge sort of touches on this in paragraph 39, doesn't he?
Yes, indeed. and if we go straight to 39, my lords will have recalled from the claimant's own witness statement that he said that at the end of the working day, his clothes were dusty. But the learned judge goes on to say, I do bear in mind that in his second statement, as no, not the first statement, the deceased says that there were clouds of dust when the asbestos was cut up. This is perhaps not surprising, but it does not follow that the deceased was thereby covered in such dust. Indeed, if there were visible clouds of dust, then I would have expected the deceased to keep his distance. There was no good reason for him to be standing so close to the carpenters that he became covered in dust. Insofar as he says that his clothes were covered in dust, again, this may well have been the case. But building sites are dusty environments, and it does not follow that the dust which he brushed off his clothes was asbestos. Well, my lords, again, just pausing for a second, there is no evidence to support the proposition that the claimant did not stand close to those who were cutting. This is the standing within a few feet of those who were cutting. There's no evidence that he was not, forgive me, there was no evidence that he was warned not to stand close to the dust. There's no evidence that he involving,
in a case involving exposure 75 years ago, how is the court meant to cope with the fact that there is almost inevitably no such evidence? It doesn't compel the court to accept what appears in the written statement admitted under the Civil Evidence Act. On one view of what the judge is doing is he's bringing his experience to bear on evidence which has been placed before him, which goes beyond just the witness statements, but does not include express evidence that he was given instructions or any of the other things. Are you saying that this approach is not open to the judge?
Well, my lord,
Or are you just saying he got it wrong?
Well, up until last week, I would have been confined to say he just got it wrong. But this is why we've made reference by handing through the case of Newey and Griffiths, because there were evidential routes open to the defendants to test the evidence. And my lord, I take entirely what is said about the difficulties of trying to recreate a world that has not existed for decades. Of course, we start from the proposition that that is not the victim's fault. The defendant, we allege, negligently exposes them to a poison that takes decades to act. So it's not a problem of the claimant's own creation, but it is a problem that must be dealt with. And so there are mechanisms, well understood mechanisms, within this area of litigation open to a defendant. And one of those mechanisms is seeking what used to be evidence on commission, now evidence on deposition. And there was a period of time, certainly a significant period of time after the letter of claim was sent, and I think from recollections of like 3 months after the proceedings were commenced, when the deceased was alive. And it's,
Go on.
I'm sorry, it is a relative commonplace within this area of litigation for defendants to ask for evidence on commission to be heard.
Is it?
Oh yes, oh absolutely. And we gather in people's houses, we sit in their sofas in front rooms. The defendants deal with the quintessentially English problem of sipping somebody's tea whilst cross-examining them. And it is one of the features of asbestos litigation. This is not esoteric stuff. And the defendants in this case chose not to avail themselves of that.
It's only anecdotal, but in my experience, it happens in hospices. People literally on their deathbeds sometimes given evidence.
And the window you say when that could and should have been done?
Well, any time from the letter of claim onwards, but certainly from when the claim was issued. So he died on the 5th of February 2022, and the proceedings were commenced on the 2nd of December 2021. So there was a short window.
And what's the date of the letter of claim?
My lord, if I may turn my back. 13th of April 2021, and he died 5 months after issue.
Hang on, sorry. I don't, on the dates you've given me, that's not correct.
10 months.
Sorry,
Letter of claim 13th of April.
13th of April 2021, yes, forgive
Yes,
me.
but I think what you just said was after issue. Issue was on the 2nd of December, and he died on the 5th of February. So that's 2 months.
6 weeks.
No, he died 5th of April.
Oh, I'm sorry. I may have either you misspoke or I misheard. It doesn't matter. It is the 5th of April.
Yes.
Yes, I see. Okay, thank you. So letter of claim. This will be quite clear about this. Letter of claim 13th April 21.
Yes.
Proceedings commenced 2nd of December 21. He died on the 5th of April 22. I got that right.
Yes.
Thank you.
And,
Yes.
and just so I'm clear, when were the witness statements sent?
Again, if I may just turn my back. 13th of May 2021 for the witness statements, and there is
Sent to the defendants.
yes.
So
There's a
that's,
chronology
they were sent a month after the letter of claim.
Yes,
Yep.
forgive me.
That must be the first witness statement because the
Yes.
second one is July.
Yes.
So,
Yes, absolutely right.
yes.
There is a chronology. I'm reminded at divider 4 of the core bundle.
Thank you. Have a look at that. Yes, thank you. That's very clear. And do we have the letter of claim?
I'm not sure we do in the bundle, but that can be produced.
Well, probably it's not necessary, given there's obviously the key things are the witness statements and.
Yes.
Okay, thank you.
And just to complete the point raised by my Lord Justice Newey, of course, in any event, the defendants had the option of issuing a Part 18 request for information. That is done less often, but it is done. And of course, that is a matter of general application. And so we say that as part of the overall matrix, this court is entitled to take into account that the first time that any sort of structured criticism of the evidence is heard, there is a response to the letter of claim, but the first time that there is a structured and detailed rebuttal of, well, what about this, what about this, what about this, is through the advocacy of my friend Miss Foster. Of course, no criticism intended, she's doing her job at trial.
I mean, that's very different from TUI, or very different from the long-established principles about the obligation to cross-examine.
Yes.
This would be a very substantial jump from saying, well, if you've got a witness, you have to cross-examine them, to saying an inference can be drawn because you haven't chosen to put in a Part 18 request or haven't chosen to ask for evidence to be taken on deposition in circumstances where the person is ill anyway.
Yes. My Lord, I take the point. But of course, equally, it must follow that in an arena of litigation that proceeds along gliding rails compared to the rest of civil litigation, because it is well understood by the practitioners involved in it that time is short. But if the defendants wish to cross-examine, they have that option available to them. To choose not to do so, and this was an experienced solicitor, Clavengate. Mr. David Wynne is a very experienced defendants insurance solicitor. Choose not to avail themselves of that, but to simply turn up at trial, and again, no disrespect to Miss Foster, raise a quizzical litigation eye, what about this, what about that, when it's too late for the claimant to make answer, because if we are right of the effect of the tort that's been visited upon him, it seems to be unfair for the judge to make concessions where there is no evidence either way.
Make concessions.
I'm so sorry.
Make criticisms.
To make findings. which reduce down the exposure when there is no positive evidence to warrant it, and the defendants themselves have not taken the steps available to them to test that evidence whilst they could. And I don't put the point any stronger than that. And I've now dealt with Griffiths and Toohey, unless I can help further on that in due course. So turning to page 40, forgive me, paragraph 40 then, back at page 69 of the bundle. Overall, I find the account given by the deceased, particularly in the second statement, to be implausible. Rather, I am driven to the conclusion that his exposure to asbestos, when employed by the defendant, was of a low order, light and intermittent, and in the main as a bystander. Well, my lords, what we say about that is this. It is right and a fair approximation of the evidence to say that the majority of his exposure was as a bystander. That must be right.
Hang on. Hang on, just want to make note of this. Yes, thank you, go on.
Equally, it is right that it was intermittent. To use the word light without qualification is wrong. There were heavier exposures out in the world, there is no doubt about that. And that if one takes an average, the figure of 1 to 2 fibres per mil is much less than the peak potential of 100 fibre mil. We accept that.
It's the problem with adjectives and elastic language,
Yes,
isn't
precisely, my lord.
But it's an inherent problem, really. I mean, you read all these cases, there's so many phrases, negligible, marginal, trivial,
it? Significant,
Not-
light.
it's
intermittent.
not criticising anyone. It's simply a reflection of the fact that these things were not measured at the time, are very difficult to measure anyway,
Yes.
and are bound to be impressionistic. But that's the nature of the exercise that the judge has to do.
Yes.
So why are you saying light was wrong?
Because when he was carrying out the acts that we complain of, the sweeping, whenever he was cutting himself, and actually sufficiently when he's standing next to somebody that is cutting, that is not light exposure.
And sweeping, cutting,
And standing next to those who are
or
cutting.
standing. Next. So one way of formulating the question would be, if someone had gone around with a suitably qualified factory inspector at the time, not conducting his enforcement role, but just there, and the facts found, or as they should have been found by the judge, so intermittent, that's the word I think we can agree on.
Yes.
Mainly low level, but with these occasions of sweeping, cutting or standing next to them. If the factory inspector, expert, suitably qualified person had been asked, the question then would have been, does this give rise to a foreseeable risk of injury?
Yes.
And the answer, there are two possible answers. The one for which you contend is, it's of a level which, in other circumstances, if continued, may give rise to asbestosis. The answer that Mr. Kent would contend for is no, although these moments are high, in the overall context that we're talking about in the 1950s, it's I'm going to use a tendentious word, forgive me, for a purpose, it's negligible.
Yes.
And that's really what this appeal is about, isn't it?
Well, there's a lot, if I may say, in what falls from my lord. And can I try and take it in stages? First, in respect of the use of language, in one sense, it doesn't matter which English word is chosen from the lexicon. What matters is what one concludes from that. And one of the areas that we say the learned judge fell into error is he put this into a pigeonhole in his mind of light and intermittent. Therefore, don't really think that Jeremson and Maguire is much to do with this situation. The guiding light in terms of authority is Abraham, and to follow what Mrs. Justice Swift did by way of her approach, and therefore conclude no exposure. Forgive me, no actionability. So it's not necessarily the label; it's what one does with the label. But the use of the label is a clue as to what the judge is about, which is to find at the end of it, compelled to say no negligible, no exposure. Equally, what fell from my Lord Justice Underhill. The descriptors can be problematic because as matters of logic they can create closed loops that don't assist the trial judge. For instance, what is not actionable? That which is de minimis. Or what is de minimis? That can be ignored. Or what can't be ignored? Anything that's not de minimis. There is a complete circularity.
Well, that's why I framed my question to you in the way I did, which is look at the context of the 1950s.
Yep.
At a time when asbestos was imported in Hessian sacks, was emptied upside down, laggers and people doing processes were exposed to, again, you can use the word clouds,
Yes.
but they're very different clouds from the clouds that are being spoken about when someone saws up a wall, or even when someone sweeps up dry detritus on the floor. And so the real question to be asked is the question that would have been asked in the 1950s. Does this exposure give rise to a foreseeable risk?
Well, my Lord has asked a different question to the one that was asked beforehand about the putative factory inspector. And I was going to turn to that next.
But can I just,
Okay, but I'm testing the one with the other.
Yes, indeed.
if any word is better than another, perhaps the right word is negligible, because technically that means such that you can ignore it,
Yes.
which implies the test was this at a level where it could have been ignored. It's still in a way circular because you can't measure it,
Yes.
but that at least focuses you on my Lord's question, which must, if I may respectfully say so, be the right question, not what adjective do you use.
Yes. I accept that, but if I can just deal with the question that was asked, what the putative factory inspector would do is not necessarily a safe test, because the factory inspector, although it has been described as the guardian of the public interest in terms of safety, is also looking at what can be done in terms of prosecution, enforcement.
Well, I deliberately said he's not there for
Yeah.
with wearing his enforcement hat.
Yes.
But I'm trying to be favourable to you in the formulation of the question, because one question on the authorities is what would the reasonable employer in this person's state with the current knowledge? If you go down the asking for advice route, you make it more difficult for the employer to escape liability, because you're assuming that the person of whom they ask advice has a high level of understanding.
Yes.
That's why I took the factory inspector. He doesn't have to be a factory inspector.
Yes.
He could be an occupational health physician if such a thing existed in those days, which it did.
Forgive me, I'm not engaging or seeking to engage, I hope, in pedantry, simply to try and deal with what has fallen, which is clearly crucial from the bench. The next stage is that when one comes to the authorities, one sees a clear division between that which was being said by HMFI, which in certain respects was inadequate. And here I am thinking of Mr. Justice Swanwick's review that in terms of scrotal cancer, the HMFI had given all sorts of warnings about don't allow bodies to touch oil because it causes dermatitis, but had said nothing about cancer. Mr. Justice Swanwick says, okay, but even the defendants didn't think that that was an exoneration. In terms of deafness, we have the judgment of Mr. Justice Mustel, as he then was, saying, look, there's a problem here, that the HMFI simply, for years, didn't do anything about this, knowing that there was a problem. But that wasn't sufficient to exonerate the employer. Equally, we then have the cousin of that point, which is raised by Mr. Machel, Queen's Counsel, as he then was, in Jeremson at first instance, that just because nobody did anything about this and there was not much pressure from the HMFI doesn't mean that the defendant is exonerated. So the question is purely and simply, what should the reasonably prudent employer have foreseen? Was there a danger or not?
Yes. What was reasonably foreseeable?
Indeed.
That's the legal question.
Yes.
But the way to test it, most favourable to you, is to assume that the reasonable employer is there with a more educated person, be they an occupational health physician or a factory inspector. So don't get hung up on my factory
No,
inspector.
no,
But the question is, or at least a test for the question of whether it's foreseeable, is whether, assuming people went round the factory or whether the school at the time and saw this, whether the more educated advisor, the person of whom the questions are asked, would say, "Whoa, you shouldn't be doing that."
Yes. And so the framework question is the one that my lord posits. The substance into which that framework is filled comes from, as I hope we'll see, reference to Merriweather in the 30s, the 30, 31 and 33 document, and also factory inspector reports, which do two things. The first is, well, three things. They say, here is this disease, asbestosis. We positively know that heavy exposures will cause asbestosis. And we also know that even asbestosis, which is not particularly disabling, may in fact have a hand in early death because it may make somebody susceptible to intercurrent but unrelated infection. That's the first thing. The second thing it says is, just because we positively know that the heavy exposure will inevitably lead to asbestosis, and that asbestosis may have the most severe ramifications, please don't assume that light exposure does not. We just don't know. The third thing that it does is to point out that sweeping is as dangerous as anything else. That sweeping is as dangerous an activity as anything else. It is a peculiarly dusty occupation. And then you've got the general prohibition from the factory inspectorate in 1938 reviewing the newly minted Section 47 of the Factories Act 1937, which, unlike other parts of the 37 Act, did not simply replicate the Factory and Workshop Act 1901. It added this new section, of course, which said, do not expose to dust, fume or other impurities.
Sufficient quantities as to be likely to cause, or whatever the word is.
Indeed.
You're more up to date than I am, but
Or substantial quantities of any sort.
substantial quantities. And again, you're back into elastic language.
Well, you are, except that there is always the gloss given to it by the chief inspector in the 1938 report saying, we know that dust physiologically is bad, cut it down. And that's why when we come to the 1960 toxic dust in factory atmospheres document, it's so important not to do what the judge did, as we'll see in a moment. Forgive me, I've been slightly blown off course. In terms of just simply saying, well, the 60 document says thou shalt keep exposure below 177 particles per cc. Actually, it's got a very long run up to that wicket, which is, gosh, 25 years ahead of the time. Ask what it is you're exposing your workers to. Find out whether it's toxic. If it's toxic, can you substitute it? If you can't substitute, can you actually fence it off so that contact with the worker is not possible? If you can't do that, can you set up a fume cupboard? If you can't do that, can you provide personal protective
When
equipment?
was COSH introduced?
1988.
88.
88.
Okay.
It's a red herring. It's simply to say that the 1960
I thought
document
for
is
one
remarkably
moment,
precise.
I couldn't believe my ears, but I thought for one moment you were playing COSH in aid.
No.
You're really saying you just go down that route.
Yes, and the 1960 document doesn't help the defendants in the way that they believe it does, because you only get to counting, and we've not even come to why the count itself is a difficult exercise. You only get to counting, really, when every other step has failed.
But the second of the 3 points you say we knew from 1930, which is, in a sense, we knew that we didn't know about light exposure.
Yes.
Maybe we'll have to come back to this, but can I just flag it up as
Yes.
differently now? If you put a lot of weight on that point and take it to its logical conclusion, the view which has become very clear in all the case law that 1965 was a watershed becomes really irrelevant, because you say, well, maybe you learnt a lot more in 1965, but you already knew that you didn't know in Rumsfeld territory.
Yes.
It was a known unknown, and therefore you should have been taking precautions against it, which would be a major upending of the way in which the case law in this field has developed.
It would. And we don't seek to do it.
Then know that that is concerning me, and explain why, in due course, at the right point in your submissions, explain why your submissions don't have that consequence.
Well, because there is the last piece of the jigsaw pre-65 that is missing, which is positive knowledge that trivial amounts of exposure to asbestos can cause what hitherto was a medical footnote, mesothelioma.
Yeah, but I see that. But the whole point of your submission, and you made this point in your first 5 minutes, is it doesn't matter that you didn't know it could cause mesothelioma. What matters is that it could cause death, or at any rate serious injury, and in some cases death, namely from asbestosis.
Yes.
In which case, finding that there are other things it caused might be thought neither here nor there.
Well, no, my lord, forgive me. The distinction is the positive knowledge that trivial amounts of dust can cause mesothelioma. Until then, it was thought that asbestosis was the gatekeeper, and it was known. It was said, and we'll come to this, that it was accepted by Dr. Merriweather. I think it was the 31 rather than 33 document, that he followed your logic and said, well, if asbestosis is so dangerous, perhaps we should make sure there is never any exposure to asbestos at all. No, he says, because there appears to be some sort of threshold.
Right. Well, it's my fault perhaps for asking the question. Though it's built on something you said. Why don't? There's been a helpful trailer, but let's defer the full movie till we get to the right point in your submissions.
Thank you. So where we left the judgment was at paragraph 40. He had said that the exposure was of a low order life-intermittent and in the main was a bystander. And I was just going to go on to say that it was of a low order was clearly not supported by the facts when one is standing in if I can, I'll not use the word cloud because that's now loaded, a concentration of fibre that is as high as 100 fibres per millilitre and that takes us to paragraph 43, where we say he makes further error. So he says this: assuming that the deceased was indirectly exposed to asbestos dust for 1.5 hours per day as a result of the carpenters cutting up AIBs, and I've already found this to be inherently improbable, and assuming that he spent approximately 10 minutes per day sweeping up asbestos dust, Ms. Conroy agreed with Dr. Phillips that his average daily exposure was in the order of 2 fibres per millilitre. I stress that this is no more than an approximation, and inevitably there would be considerable variability from day to day. Nevertheless, this measurement does provide some insight into his likely overall level of exposure to asbestos dust. And what we say at the moment is, well, as an average, yes, but as we'll see, I hope, in a short while.
Have you recognises that?
Yes, but what he doesn't do is fully advert to the fact that there would have been much higher levels of exposure particularly when sweeping. And the average doesn't assist in dealing with those spikes of exposure. Because, as again, I hope we'll see from Lady Justice Hale in Jeremson, one takes the risk from the highest level of measure.
It takes the foreseeability of risk.
Yes. Yes. Thank you. he then, having dealt with the expert evidence, and I hope I can gloss over that because time is passing, goes on to consider the literature and concludes at paragraph 76. This is at page 77. With those preliminary observations, I turn to what the defendant should have known in the mid to late 1950s about exposure to asbestos dust. Undoubtedly, the message that was to be taken from the literature to which I have referred was that asbestos dust was highly dangerous and that its inhalation was to be prevented as far as possible. And it needs to be emphasised that that message was delivered in the context of the known risk of asbestosis and of occupational exposure to significant quantities of asbestos dust. As in Abraham, the question which needs to be asked is whether the information then available should have alerted an employer to the possibility that an employee whose exposure to asbestos was light and intermittent might have been at risk of contracting an asbestos-related injury. And my lord, what we say here is that, again, picking up on what has fallen from the bench in terms of the elasticity of language, he is now relying upon his overall conclusion that this was light and intermittent exposure. We say it was not light and intermittent, it was substantial.
If you take paragraph 76 on its own,
Yes,
it's okay.
yes,
But he's not expressing his conclusion, he's expressing the test.
yes.
And you don't, as I understand it, you don't quarrel with paragraph 76 on its own.
No.
Thank you.
What I was going to do was to try to gain some insight for the court as to what he was considering, what had to be proven before one escaped the language light and intermittent, and hence one's found oneself in the trap of having to go and follow the results in Abraham. And we can see this, we respectfully submit, from the evidence and the submissions. And I will, if I may, please take you back to this. So I'm now in the Cuthbert supplementary bundle. First divider, page 56. And letters B.
So sorry, where are we?
Page 56, my lord, please.
Of
divider 1.
sorry, which bundle?
Bundle.
Oh, sorry, no,
Supplementary
I'm in the
bundle.
wrong bundle. There.
Yeah.
Okay. Yes, thank you.
And this is a passage that commences at letter A. Judge Freedman, I'm grateful to you and to Ms. Conroy. At this point, Dr. Archer has given evidence for attempting to quantify the level of exposure averaged over a working day. But of course, it's a highly artificial exercise because you do not have the raw data to start with. But more particularly, it is not an exercise upon which any employer could or should have embarked at the time. No. So really, the test that has to be applied in situations such as this is whether there was, one has to use relatively loose language, I would have thought, to determine whether or not the exposure was significant, both in duration and intensity, or whether it was intermittent and light. Yes. I mean, would you disagree with that approach? I think that's probably a fair, I mean, in my view, at the material time, the defendants wouldn't have had no idea of the nature of the hazard, let alone the extent of that. So what appears from this passage, we respectfully submit, is that the dichotomy in the judge's mind is that one either has significant duration and intensity.
Who is this giving evidence?
So this is Dr. Phillips, the defendant's occupational health physician.
We're looking at this not for the evidence, but for what you say shows the judge is thinking.
Indeed.
Not terribly happy about that. You just look at the judgment for his thinking rather than things he says as the case goes along.
Well, I wouldn't ordinarily attempt the exercise, save for the elasticity of language.
Okay.
Um,
Well, I'm not stopping you. I'm just putting down a marker that, you know, judges are thinking aloud to some extent as the case goes on.
I take that. And we don't wish to be carping. But it's difficult to see from the judgment itself what the meaning, the words used by the judge held for him, because it's difficult to understand from reading the judgment itself why he doesn't really grapple at any stage with the fact that the evidence before him, agreed evidence, was that when sweeping, exposure could be up to 100 fibre mils, and nobody could fairly describe that as anything other than heavy. And I won't take it any further than pointing to one further passage, because either my lords are impressed with the point or they are not. And repetition won't assist. But if we turn to page 86 in Divider 2, and this is the section from the submissions, where the learned judge is hearing from Ms. Foster. Page, E.
Which page?
Page 86. Is the other point that the impression that one gains from reading those early publications is that the concern is in relation to frequent, regular and heavy exposure? Answer, it is yes. And actually, as I hope we'll go on to now, see that that is not a fair summary of where Newhouse and Thompson takes us.
So what do you want us to take from that?
Again, the dichotomy in his mind appears to be that if one doesn't have frequent, prolonged and intense, then one must be in the category of light and intermittent. There doesn't seem to be, within the judge's sphere of thought, the idea that there could be substantial but intermittent, or heavy and intermittent.
Hang on one second. So what the dichotomy he's making is between heavy and prolonged.
Yes.
What's the opposite of intermittent? Heavy and continuous, really.
Yes, yes. Or light and intermittent.
Whereas you say foreseeable risk from heavy but intermittent.
Yes, or substantial or intermittent, or more than negligible in intermittent. But effectively, we say the trigger is the visibility of the cloud of dust.
Okay.
He then does review the case law that we'll come to, but his overall approach is that they don't apply, so particularly Jeremson and Maguire don't assist, because they are all positive, forgive me, Owen and Emma and IMI and Jeremson. They don't assist because the factual background before the court in those cases was exposure that was really very much higher than is complained of in this case. And our
Just as a matter of interest, do you accept that the exposure in Jeremson was much higher than here?
No, absolutely not. Let me make good the submission. It may have been higher, but not qualitatively higher, because as we'll see when we get to the judgment from Mr. Machel, that he had before him a league table of exposures that were evidenced in that case, one part of which was sweeping and which was deemed by the experts to require the same epithet same descriptor as knocking lagging off pipes and then mixing asbestos to put it back on. So our position would be that when you look at the language as used by Mr. Machel and the evidence he had, we submit, would have looked at the sweeping in this case and put it in the same bracket that he was looking at in Jeremson. At paragraph 83, forgive me, he says at 81, there can be no doubt.
Sorry,
I'm so sorry.
we're going back to the.
We'll go back to the judgment. I'm sorry, I should have made that clear.
J+3.
Yes, page 78, divider 6 of the core bundle.
Yeah.
Para 81, there can be no doubt that the degree of exposure is relevant to the question of foreseeability of risk. And we accept that. That is a full, proper, adequate explanation of the law. And then he drops down by way of a cross-check, having found that the exposures here were insufficient to give rise to that foreseeable risk. At paragraph 83, where he says that he adopts the approach of Mrs. Justice Swift and Abraham, reaching the same conclusion, that there wouldn't have been a foreseeable risk. And we would like to pick it up halfway down that paragraph, where it says, whilst it is correct that there was no safe level of asbestos exposure at material time, nevertheless, even the permissible level of exposure, which was set in 1970, was far in excess of the levels to which the deceased was exposed. This is not conclusive, but it points strongly in favour of the proposition that the material time is a matter of law. The defendant was not fixed with knowledge that asbestos exposures at the levels to which the deceased was subjected gave rise to the foreseeable risk of injury. And the comment we make there is that we believe the reference to 1970 is to Technical Data Note 13, TDN 13. My Lord Justice Underhill will recall TDN 13 was the object of scrutiny in Bussey. And that it was found that that document, albeit setting a prosecution level and not a safety level, set its trigger at 2 fibres per millilitre of air. And it seems to us that it cannot be said that that limit is far in excess of the evidence before the learned judge in this case, because he had decided on the evidence that the average was 1 to 2 fibre mils, and it could be variable beyond that as well. So, my Lord,
Hang on 1 second.
yes.
The concession, whilst it's correct there was no safe level of asbestos over material time, begs a lot of questions. It clearly means by it something different from no foreseeable, finding whether there was a foreseeable risk of injury, but you might say, well, in that case, why can't you say there was a safe level, i.e. one at which there's no foreseeable risk of injury?
Yes.
Perhaps it's a question of not. I think. Sorry, I'm just thinking aloud.
No,
It's really a point about measurability.
yes,
Yes, I see.
yes, because nobody could have measured that level, which is why, as we'll see when we get to Mr. Machel's judgment at first instance in Jeremson, he alights on, well, what can you do? Well, you can see that there's a visible cloud of dust, and that should put you on your mettle as an employer, because you can't measure it. What you can then do is take steps to try to replace it with a non-poisonous substance, or any of the other steps that I suggested are available to be read in the subsequent 1960 toxic substances document.
Yes, sorry, I said no measurable level. Perhaps I really meant no quantified level.
Yes.
Yeah.
Can I then deal, and I'm very conscious of time. It's,
Well, don't be that conscious of time. You're going to a good pace. So I think it follows from what I said earlier that if you go a bit later, it doesn't mean everyone else is going to have the same amount of time. So keep up at your present pace, and you're okay.
well, I'm obliged. Can I then please turn to the core documentation? And this is all in Supplementary Bundle 2. Divided
Just hold on a second.
I'm so sorry.
For some reason, my machine has just installed a new update. So I'm now looking
We
at
can always have a cup of
my
tea.
screensavers while I just get back to.
We in Chambers are having to deal with Intune, whereby Chambers now controls our computers, which tends to lead to flash breakdowns, which is why when I saw Malone for Mr. Steinberg is relying upon a computer today, I gave a low whistle of appreciation.
Well, some of us still, at least in court, relying on pen and ink, which I find never lets you down.
I think the ultimate proof of the elasticity of time is the fact when you watch an advocate who's lost their place electronically and you realise that each second expands to an hour as they find their place. It's
Just, I don't know what's going on at the moment. Just give me a moment. Again, I'm back with you.
very conscious.
Right, the update is complete.
I'm right. Forgive me, I was just talking to Malone about timetable. So all the documents now are in the second supplementary bundle, and if we could turn please to divider 12, page 47. And this is just to introduce the Merriweather and Price report to the court. The front sheet at page 47 shows.
So sorry, which bundle are we on?
We're in the second supplementary bundle.
Yeah,
In
okay.
Cuthbert.
Yep.
Divider 12, please.
Yeah. Yeah.
Just to explain the document from its frontispiece here, the two authors, Dr. Merriweather and Mr. Price, one can be seen to be the medical inspector factory, that's Dr. Merriweather. Mr. Price is the engineering inspector, and that's why the report is in two parts. Part one deals with the medical, part two with the engineering. And if we turn the page over, one can see that this was a report requested effectively by the then minority Labour government in 1930, arising out of cases of fibrosis that appeared to be connected with the asbestos industry. And if I can just take the court to the Chief Inspector's covering letter in two respects, at page 48. He sets out 4 lines down that the report establishes the facts that the inhalation of asbestos dust over a period of years results in the development of a serious type of fibrosis of the lungs, that the development of the disease varies in direct proportion to the length of the exposure to dust, and that susceptibility to the disease is not affected either by age or sex. Then he goes on, the remedy for these conditions is to be found, as in the case of so many industrial diseases, in the suppression of dust. And he then sets out what some industry-specific steps have been taken. And the final sentence is, in our respectful submission, also of importance. For the textile section, it is evident that a good deal of experimental work will have to be carried out before completely successful ventilating appliances are evolved effectively to remove all the dust. And so it would appear that the factory inspectorate at this stage was seeking to move to a no-dust model. For my Lord's note, the background and history of why this report was required is set out in the introduction section of page 51, which I don't intend to read. But the scope of the investigation, which appears at page 52, is of importance. And if one starts at 3 and then goes down to the bottom of page 53 on the next page, I hope I can summarise it fairly in the following way. It was understood by the reporters that there were two types of worker in industry. There were those who were exposed to asbestos in addition to other dusts, because asbestos was only an incidental part of their work. And their number was unknown. And for them, the inhalation of asbestos dust would have confounding factors of inhalation of other dusts and substances. To be contrasted against them was a more narrow cohort of people, 2,200 in number. And they were those who were asbestos workers. They were only exposed to asbestos dust in the main. And since the whole point of the exercise was to try to work out the deleterious effect of asbestos dust, it was decided to concentrate on them alone. I delay the court by pointing that out because it points to a hidden truth within the report, which is this: because they chose asbestos workers, they were necessarily dealing with people who had heavier exposure. It does not find voice within the report that they looked at them because they were thought to be at a special risk. It was just that they were a clean cohort, limited in number, the size of which was understood so that they could understand the sampling numbers that they were dealing with. That is, they worked out that they were talking to about 1 in 6 of the asbestos workers. Of equal importance is that they found comparatively few workers who had been employed for more than 10 years, and lots of workers who'd been employed from 0 to 4 years. They don't explain why this is so, whether that was a sinister thing or because the work was unpleasant and people just wanted to move on. But what it does mean is that their sampling of those who had been exposed from 0 to 4 years was lower in number than those who were sampled 10 plus, because where they found a 10 plus year worker, they made a beeline for examining them. So there is an inherent skewing.
Well, that's right. But then the finding was no cases in 0 to 4, which I think the way the tables 1 and 2 are set out, 0 to 4 means 0 to 5th birthday.
Yes, of exposure. Yes, absolutely.
So no cases, as you say, all heavily, likely to be, not necessarily all, likely to be heavily exposed, and no cases in 0 to 4 years.
Yes.
In the sample.
Yes.
Well, I didn't quite understand the point you were making about the long-term people, because there were 15 to 50. There were more in the sample from 10 to 14,
Yes.
proportionately. There was more, but not by so much, for longer periods than that.
Yes.
And I don't quite understand what the point you're making.
It's a side issue. It's simply this, that there would tend to be greater statistical power in what they were finding in the 10 plus year cohort, because they were actually interviewing a greater proportion of that than they were of the 0 to 5 years.
But with the way the numbers came out, their skewing was justified.
Yes, it was completely justified, but it has to be understood by the reader, the putative employer who reads this intelligently, that the study was always more likely to pick up disease in those that were exposed for a longer period of time because it was talking to more of those. That's a simple point.
Yes, just so that you know where I'm coming from. On rereading this in preparation for today, almost the most important two features, well, one, the one that you've made, which is its heavy exposure. And 2, no cases in 0 to 4.
Yes. Yes.
And I think that's, if you like, pretty central to the defendant's argument.
It is certainly what they rely upon. Yes, absolutely.
Yes.
It's not for me to put no offence case. No.
Just okay. At least I understand that we're in agreement that the 2 most striking things are 0 to 4 and heavy exposure.
Yes, absolutely. And by the time we finish with these 3 documents, I hope I've persuaded my lord that when read as a trio, it was clear, absolutely pellucidly clear, that the author, Dr. Merriweather, did not want somebody to go away with the impression that because they couldn't find somebody below 4 years, there was no risk. By way of background, and I won't read this out, the medical effects of asbestosis are set out at page 55 under the rubric of 4 results of the inquiry. Can I now start to chip away at the no cases below 4 years? And can I turn to page?
So I'm being slow here. Why is that material?
Because the defendants will say a prudent employer looking at this report would say to themselves, aha, there were no cases of people who were developing fibrosis below 4 years exposure. 5 years, 5 years, forgive me, 5 years exposure. And therefore, for somebody that was exposed only intermittently, one can work through, well, hang on, that's the equivalent of perhaps working permanently for less than 5 years. Therefore, there's no risk.
Well, I obviously hadn't read the skeletons properly. I hadn't appreciated that. To me, at the moment, that seems a fallacious point. But if it's being made, you better deal with it.
Well, that is what I'm moving to now. Can I commence doing that by turning to page 56 and taking the second full paragraph and 4 lines from the bottom, we get the following. Applying the rates shown in table 3 to the figures in table 1, it appears that the general incidence rate...
Sorry, which page, where are you?
I'm so sorry, page 56, second full paragraph,
Yes, thank you.
5 lines from the bottom.
I have it, thank you.
Applying the rates shown in table 3 to the figures in table 1, it appears that the general incidence rate of fibrosis of the lungs amongst those employed in these sections of the industry is rather less than 1 in 8, or, excluding those employed under 5 years, rather less than 1 in 3. So what is not being said is that there is a nil risk for those under 5 years. They just carve out the under 5 year exposed and give the comparative figure. And then to drop down further to make sure that no employer reading this could possibly over-interpret it, the next but 1 paragraph commences as follows. These general incidence rates are convenient merely as affording a rough indication of the inherent risk associated with exposure to asbestos dust at the present time. They have no permanent value, either as an index of the general risk of fibrosis in the industry from year to year, or as a measure of the risk in any particular factory or group of employees. Now, turning the page over again to page 57. One can see underneath the table the following sentence. These tables indicate the outstanding importance of length of employment and hence length of exposure to work, and the negligible effects of age on the production of fibrosis. 2 little points to make here. The first is that there is therefore a positive case arising from this paper that heavy exposure for a long period of time does, not will, may, does lead to fibrosis, but is silent on the antithesis of that. What is the position if there is lower exposure or very little exposure? But the second is this: just in case it was in the mind of an employer that those who are young, with perhaps to be expected greater capacity to withstand bodily insult, were protected in some way, because Mr. Cuthbert, of course, was 17, then there is no comfort to be had from that direction. And again, if one looks to 1, 2, 3, 4 paragraphs below that, still page 57, turning to the effects of length of employment. Turning to the effects of length of employment, a very different picture is seen. Table 3 shows that after 5 years exposure, the incident rate mounts rapidly, and after 10 years increases almost in geometric progression. Again, the positive case that heavy exposure for a long period of time is deleterious, but there is no exoneration for those that are short periods.
That's not right. And there's no express exoneration. There's no evidence of short periods, even of intense exposure, giving rise to fibrosis.
That is the result, absolutely. But that is not the conclusion. It is signally not the conclusion that is being drawn here.
In that case, I don't understand your last submission.
Oh, I'm sorry, I'll try and make it better. We say, and one has to look at the picture that was being built up. This is just one part of the picture, but we say, we accept that these paragraphs direct themselves expressly to what happens if there is substantial prolonged exposure. And they say it will cause injury. And the more you're exposed, the more likely that is. What they signally do not say is that therefore you can consider that there is a cut-off or that there is a safety below a certain level. It's simply saying we positively know that heavy exposure is dangerous. It is, we respectfully submit, conspicuously silent in drawing any conclusions about low and light exposures.
That's not how it was interpreted at the time. You look at the asbestos regulations and the scheme, which expressly exclude from compensation people who haven't been employed in the last few years. Or am I misunderstanding the position?
No, the answer to the question is how long has my lord got? There are
Plenty
literally.
of time thereafter.
I'm so sorry. I didn't mean to interrupt. There are literally books written about the effect of lobbying, which took place in respect of the 1931 regulations and the benefit system that was extended to them. The vector by which that occurred was that the Factory Act required a promulgation process, perfectly reasonable, by factory inspectors whenever there was going to be a special set of regulations incurred or promulgated. And that if they couldn't be agreement obtained, the factory inspectors would have to hold an inquiry. Nobody wanted that because they were expensive. And so what would happen is that the inspector would start to liaise with manufacturers to hear their side of the story. And it is argued that there was capture as a result, and it's argued that it happened again in the 1969 regulations. Put that to one side. In fact, one of the documents I'm going to go to in a very short while, we respectfully submit negates the point that's fallen from my lord, because one of the tasks that Merriweather puts himself to is asking about the role of packers.
Role of what?
Packers, my lord.
Okay.
People who are not asbestos workers in the true sense of the word. They're not the ones who are doing the cutting and the ripping and the creation of asbestos mattresses. And even here, Dr. Merriweather found that there was a risk, and that if they developed fibrosis to be called asbestosis, they should be covered by these regulations. And so even as early as the early 1930s, we are starting to see a practical understanding by the regulators, Partridge Miller and Friends regulatory response arguments, that one of the problems with asbestos is it's like water. It gets everywhere. And you can find damage being incurred by human beings exposed to it in situations that you didn't foresee because they don't have the label of asbestos worker. And that's why what the factory inspector chief says in 1938 is of such cardinal importance about section 47. If in doubt, and if it's dusty, stop it. Can I then please turn to page 59. Halfway down the page, the phrase concentration of dust and length of exposure necessary to produce fibrosis. And here it said, from the data so far examined, it seemed clear that fibrosis of the lungs is a definite occupational risk amongst asbestos exposures, asbestos workers as a class. Furthermore, it appears that the risk falls most heavily on those longest employed and on those engaged in the more dusty processes.
Forgive me, I was behind where I.
Not so loud. So page 59, halfway down in italicised font, it's that next paragraph. And that simply repeats the point that I've just made. It signally is silent on the issue of lower exposures. And then further cautionary notes are found in the penultimate paragraph on that page. Investigation of this important matter. Concentration of dust and length of exposure necessary to produce fibrosis from the clinical side is beset with difficulties. One of the most confusing being that the existence of a clinically recognisable diffuse fibrosis is quite compatible with continued work in the industry, and therefore the cases of fibrosis discovered in such an investigation as this are in various states of the disease, with the result that a point at which they first became recognisable clinically cannot be ascertained. So you have a disease of insidious onset that may cause the damage that you will have read in the section on what does asbestosis do, that is, give rise to a risk of premature death, even when the worker is happily working. So again, it's why you have to keep drawing back to universals. I'm an employer, can I see dust?
But that doesn't explain the nil return in 0-4 because there were radiographs and.
There were, although, and I've not taken the court to this, but if you read it, you'll see that there were issues about those workers who were situated remote from any radiographic centres, and that they may not have been properly or indeed.
That some people may not have been X-rayed who would otherwise have been.
Indeed. And it just goes to the mechanics of this is a very early exercise in epidemiology. It's way ahead of its time in many ways. But that shows the sort of difficulties that they had, that imaging was limited to X-rays. X-rays weren't universally available. And so again, if one looks at the point in this way, my lord, if you're an employer, you know what conditions your people are working in if you've got half a mind to their safety. You know that it's dusty because you can see the dust. It's a nice, broad way of looking at things. And you know that asbestos dust can cause an insidious disease, which if it doesn't kill you directly, may well kill you indirectly. And they have such a level of control over these employees' lives in exchange for a few shillings an hour. It's really the situation that was in the mind of the Chief Inspector of Factories in 1938 when he talks about the importance of section 47. You look at dust, you see dust, you do something about dust. And then can I turn please over to the page, the bottom of page 60. And this I hope goes some way to meeting directly the point that's been raised by my Lord Justice Newey. At the very bottom of the page, while no definite case of fibrosis clearly due to asbestos dust was found amongst workers with less than 5 years exposure.
I'm very sorry, I didn't hear the page.
I'm sorry, my lord. Page 60, please.
63.
Sorry, 60. 60.
Thank you.
In our bundles, perhaps in yours as well, the top lines on page 61 aren't fully legible, but you'll read them out. I'll just note them in.
It's difficult to read. I've been trying to find a better copy and I've failed.
In our bundle.
Oh, is it? Oh, thank you. I didn't realise that.
Core bundle. Yeah. Our core bundle, page 3.
Might I invite, forgive me, I don't have that document. Might I invite my learned friend just to read out that sentence commencing while no definite case?
Sorry, the top of page 61.
Yes.
Yeah. It should say exposure to high concentrations of dust cannot be ruled out. 3 cases were found with 3.5 years.
3 cases were found with, and then the second line after the word respectively.
But in each there was.
Thank you. Thank you.
Yes. So we say, forgive me, Lord Justice Stuart-Smith, I do apologise. We say that is a direct answer to the point that there is a warning starting to be given here that please do not take comfort from this. And then if we turn over the page to page 61, two paragraphs down, to sum up, therefore, it seems probable that concentration of dust and length of exposure as factors in the production of fibrosis are interdependent within certain limits. Whilst it seems necessary for the production of generalised fibrosis of the lungs that a definite minimal quantity of dust must be inhaled, the lower the concentration of dust in the air breathed, the longer the lapse of time before the fibrosis is fully developed, and within a certain limit, the higher the concentration of dust, the sooner the fibrosis becomes fully developed, and the more intense the involvement of the lung
Sorry, I
tissue.
wasn't keeping up. Which paragraph is that?
I'm so sorry.
Or which
my
page
lord,
is that?
Page 61.
Yep.
3 paragraphs down.
Yep. Thank you very much.
To sum up.
Yes, I see.
And then the next paragraph goes some way to also explaining how this was all to be approached. If this hypothesis is correct and the evidence points to it, the practical inferences are of very great importance, since it follows that the application of measures resulting in the reduction of the concentration of dust in the air in the neighbourhood of dusty asbestos processes will cause, firstly, a great increase in the length of time before workers develop a disabling fibrosis, and secondly, the almost total disappearance of the disease as the measures for the suppression of dust are perfected. And then if we just drop down to the second paragraph from the bottom, and I'll seek to just sum up this page, there is no doubt but that fibrosis of the type produced by asbestos can of itself lead to complete disablement and to a fatal termination, and this in the absence of a superadded tuberculous infection. So, what we respectfully submit is this. First, the disease of insidious onset that can kill directly or indirectly is one, the progress of which requires some threshold.
Sorry, if this is you'll have to do this at dictation speed unless.
Sorry.
What is one that?
The insidious disease, asbestosis,
Yeah.
which can kill directly or indirectly, is one which can be controlled by reducing exposure.
Okay.
With the intention being that it never causes sufficient symptoms to shorten working life.
Well, we don't really need that last bit, do we?
Well, my lord, we do, because it's
Okay,
part of the...
okay, then with the
Well,
intent.
if I tell you why, my lord, Mr. Platt may well be relying upon the British Occupational Health Society limits of 2 fibres per mil obtained in 1967. But they were a compromise. They never suggested, as I understand it, and I'll be corrected if I'm wrong, that they were objectively entirely safe levels. They were simply levels below which the risk of asbestosis was limited to 1%. So the entire approach, and we can see it here, is to manage so that workers can continue to work. But the more important measure
Sorry,
for
but your phrase was with the intention being that.
the working life of employees is not foreshortened.
Okay.
And that's a working life. Where does the working life bit come from?
Well, because the BOHS 1967 document that I think the learned friend will refer to,
So Derek is not in Meriwether and Price.
not here.
No.
It is a little later.
Yes, I see.
But the way
Like,
the
don't worry now. Yes, I see.
Okay, that was your first proposition. What
and the
was your
second
second?
is that it highlights the need for the suppression of dust. And then the final point is from part 2. And I can take this very quickly. Pages 76, 77 and 78 are evidence for the proposition that
Sorry, pages, yeah.
76, 77, 78.
Okay.
That dry dust control should be replaced for wet methods of dust control. That is at the bottom of page 77. And that is the analogy to dry sweeping. And that alternative methods to dry sweeping were being recommended even in 1931. At the top of page 77, reference to vacuum cleaning. And my lord, that final reference, please, I'll take you to, is at page 77 as well. The last full paragraph commencing the appropriate methods of suppression of dust may only be fully determined when the harmful effects of comparatively low concentrations of asbestos dust are duly appreciated. My Lord Justice Stuart-Smith, forgive me for the misappellation before, that we say goes a long way to meeting the point that concerns my Lord. The next document is to be found within the white reference literature bundle index at page 1219. No,
Which bundle is that?
and the page that I'm giving you is the electronic page,
Sorry, 1219.
1219.
Which bundle is that?
This is the white
Yes, but which bundle?
reference
Five.
literature.
1219.
Bundle 2.
I'm sorry, I've only got it electronically, so all I know.
Oh, I see. Bundle 2. Thank you.
I'm so sorry, I can't help. I do apologise.
I found it. And actually, to be fair, I got my clerk to mark up the bundles with different lessons for people who are doing bundles in future. If you're going to have lots and lots of bundles with continuous paging, mark on the back which pages are in which bundles. Okay?
1219, did you say?
Yes,
Does say at the foot of the page.
yes, it's 1960.
Mine hasn't got pages.
Right. There was a slight debate behind the scenes. If you can see at the bottom right-hand side of the page a number 1960,
I can't.
then the PDF page number is, as I understand it, page 1219. But no good if my lord is not dealing with a PDF, of course.
I've got a hard copy bundle
Yes.
with no page numbers. It's got page numbers in some, but not others.
Are you after a page which has a heading substitution?
I'm
I'm on the wrong page.
yes, I'm on the page onset and maturation of the disease.
Okay.
Memorandum. That's
And
what
I
it's
found
supposed
it as well. I mean, it's odd.
Well, I haven't. So, which paragraph of the document is it?
So this is it's an extract from the paper. Forgive me, the periodical tubercle.
I don't know that this is what I'm looking at.
I'm so sorry, I can't help, we didn't produce these bundles, I'm afraid.
No, but you're referring to them.
I am, no, I'm not trying to exonerate myself.
No,
it's just
no,
I
no,
can't
all right,
help.
no.
Do you have
fair
tab
enough.
numbers in your version?
Nineteen sixty is the hard
Okay,
copy.
this should have been foreseen by whoever was doing it.
1290. 1960 is the hard copy. 1220 is
We did try to, I'm so sorry.
No, okay, and let's not attribute blame.
Tab 52.
Let's find a way forward.
Tab 52, I'm told by my little friend, Miss Foster. I'm very grateful. Thank you.
Tab.
52.
Okay. Well, I have to say, in my bundle, 1219 is part of tab 36. Is it a page? Is it a page which has
It's
two columns?
1960.
Yes,
And in the left-hand column is a heading substitution. I think you said that earlier.
no,
And not always tab 52.
Electronic.
Yes.
Tab 52 seems to be
1960 is hard copy.
1960 is the hard copy. That's the number I've got here that we've been served with.
Sorry. So I should be going to page 1960.
Please.
Which bundle? You don't. Well, I'll
that's
work out
bundle
my
4.
which is bundle 4, right? Okay, I say it's not to attribute blame, just for learning. I hope the person who put these bundles together is in court and is realising why it matters to think about these things.
I don't attribute blame, I don't seek to, but I turn to my right.
Right. Okay. Page 1960.
And you see, I hope.
Yes, I'm sorry. And one more. That's okay. Page 1960, which is in fact it's a landscape page.
Yes.
But which means the page numbers are sideways on at the top of the page.
Of course. Anything else would be too simple.
Now, it'll sound as I'm just being tetchy. I'm not. I'm just
it
so
gets in the
people
way.
know how this doesn't work easily. Okay, I have got page 1960.
I'm very much obliged for those patience. So on the right-hand side, you'll see, I hope, a memorandum on asbestosis by
Yep.
the same Dr. Merriweather. The first stopping off point is 4 paragraphs down. Any manipulation of asbestos therefore produces dust, which is easily projected into the air. So we know it's a substance that wants to escape. Different varieties and grades of asbestos also differ material in dustiness. The next sentence is crucial.
Read the first paragraph.
Sorry.
Read the first paragraph.
My learned friend wishes me to read the first paragraph. Within certain high and low limits, the concentration of dust in the work of workrooms is the determining factor in the onset of the disease, and also within limits, concentration of dust and length of exposure determine the incidence rates in different processes in the industry. These limits will be discussed later as they have an important bearing on the scope of preventative measures.
I'm very sorry. I'm so slow. I'm still on page 1960, and I think you've gone further.
No, I haven't. I've gone back to the first sentence on the first
Within
paragraph.
certain high and low limits. Okay,
Yeah,
fine.
by invitation. Where I wanted to take you to was a little further down the page.
And the disease here, in fact, is not, may not matter, but just about accurate, is not asbestosis as such, but is pulmonary tuberculosis. Is that right? Oh, no, sorry,
It is asbestosis.
it is asbestosis. Yeah.
The title is a memorandum on asbestosis.
Yeah, I'm just puzzled it starts the Roman 6.
Yes, well, because you'll see that just underneath the title it says continued from page 81.
Yes, I see. Yeah.
Yeah,
As long as I don't need to understand it, I won't trouble to understand it. Okay.
I'm right. The next sentence is crucial. That is after the one I first read out, any manipulation of asbestos dust. Exposure to asbestos for less than 5 years can result in the development of a degree of asbestosis sufficient to cause death.
Read next sentence. You're going on.
Commonly, however, cases of definite asbestosis are not discovered on examination within 5 years of commencing work, although a few are found. So something has changed in the knowledge between 31 and 33. Nil are found in 31. As my Lord Justice Stuart-Smith has said, there is nothing to be found under 5 years in 31, but in 33, a very stark sentence coupled with the evidence behind it starts to emerge. And then if we turn the page over,
And next sentence. But, Lord, I hope
No, it's okay.
it's not inconvenient, but this was a document that I might have taken the court to, and I can save time.
Yes, I see.
If
No,
the
well, in that
references
case,
are done now.
yes, no, it will save time
Thank you.
if we have Mr. Kent's bits as well as yours.
yes, well, I'll just ask what would you like me to read?
Well, it's the next sentence, it's the one you just read.
And anything else? Or?
I'll tell you.
Right. So exposure to asbestos for less than 5 years can result
You've done that.
Yeah. in the development of a degree of asbestosis sufficient to cause death. Commonly, however, cases of definite asbestosis are not discovered on examination within 5 years of commencing work, although a few are found. Thus, amongst 89 asbestos workers with under 5 years employment examined in 1928 and 29, no case of diffuse fibrosis clearly due to asbestos was discovered. And amongst 749 such workers examined recently by the Silicosis and Asbestosis Medical Report, only 4 cases were found.
Can you just give just the page?
Yeah, sure. To continue, amongst those work.
Lord,
Would it be quicker if we just
to
read the whole
end.
paragraph?
Yes, it's simpler if your lordships could do that rather than having it read out.
Yep.
Okay.
Thank you.
Awesome.
Give us a second and we'll tell you when we've done it. Well, speaking for myself, and I imagine for my lords, we read to the end of that paragraph just at the top of page 110,
Thank you.
internal page 110. Is
And-
that right?
Yes, please. If you could also continue, I'll read out the next few lines. While these figures show clearly the increasing risk with continued employment, it would be wrong to assume that the opposite inference, which the figures appear to support, that so long as the period of exposure does not exceed 5 years, the risk of contracting asbestosis is almost negligible, is correct. Unfortunately, that inference is wholly untenable. The fact is that work in a dense concentration of asbestos dust over a comparatively short period will lead inevitably to the development of a profound fibrosis, provided that the worker lives long enough for it to develop.
Yeah.
Is that all you're reading? No. No. Okay.
The next paragraph, in summary, explains why this may be so, because of the biological longevity of the fibre within the lung. It just doesn't, it gets incarcerated, is the word used, it doesn't escape.
Yeah.
Um,
Well, none of this is very surprising, is it?
No.
Because you're not. It'll take time for the disease to develop.
Yes.
Yeah.
Yes. And there is a lot of complementary evidence in the years afterwards, but nobody's ever suggested that this formulation of incarceration is wrong.
I haven't actually seen the word incarceration. Where do I?
If you have a look at page 1962,
Oh, I see.
under the outlook for the individual affected worker, you'll find it there.
Yes, thank you.
And at the top of that page, just to, I hope, make a point that I think Mr. Kent would want me to make, if you can see the number 2,
Which page are we on now?
still same page, 1962.
Yeah.
The shortest length of exposure to asbestos dust, which ultimately caused death from advanced fibrosis of the lungs, was 4.4 years.
I can't see that. Sorry. Under the heading 2, the extent of the disablement.
No, I'm
Oh,
so
I
sorry,
see another
the
2. Sorry, the 2 at the top of the page. Yep. Got it. Thank you.
And then if we go to the next page, which is 1963, but the left side division.
Yes.
You'll see what I adumbrated a short while ago. If only the slightest exposure to the dust results ultimately in death, then the scope of the necessary preventive measures is summed up in one word: prohibition. For practically speaking, it is impossible to prevent such exposure. Fortunately, however, there is evidence that an appreciable amount of dust must be incarcerated in the lungs to produce a serious degree of fibrosis. Inquiry into the relative dustiness of various processes and the relative incidence rates of asbestosis amongst workers in those processes provides data which go far to confirm that point of view. They then seek to make good that assertion by dividing into job types a number of cases, a number of types of employment. If I drop down to the next paragraph, the groups of processes differ in their average length of dust production. The next part's important. certain operations cause intense clouds of dust, although sometimes only momentarily. With high concentrations of dust, estimations of particle count are liable to gross errors of underestimation. But nevertheless, such counts show that some operations may be at least 12 times as dusty as braiding. So the point I want to make from there, or take from there, invite the court to take, is that there is now a direct analogy with what was being suffered by Mr. Cuthbert, which were short periods of intense exposure when sweeping.
Was this
Well, no,
was
but-
this drawn to your to the attention of your judge?
No. It's part of the... Well,
Referred to in Jeremson.
it is referred to in Jeremson. And of course, my lord, when we get to Jeremson,
Well, I mean, you're putting a huge amount of weight on this because you're saying whatever Merriweather and Price says in 1930, the situation's changed by 1932. I mean, speaking for myself, my experience may not be as great as yours, but I've never read this document before.
No.
And if it wasn't drawn to the attention, if it's to be central plank of your appeal, I think we're entitled to know why it wasn't drawn to the attention of the judge below.
I think there's always a winnowing process. Indeed, well,
That's one way of putting it. If this is a central document, I must express some surprise that I've never heard of it and come across it before, and astonishment that it certainly, in your case, I don't know about in White, whether it was drawn to the attention of the judge in White. I can't remember, I've not seen a reference to it. And it's a profoundly unsatisfactory basis for bringing an appeal on a finding of fact.
well, my lord, we would say that there are aspects of this, of course, that are factual, that it is a mixed finding of fact and law.
Still pretty unsatisfactory in my, speaking entirely for myself.
My lord, we take what falls from the bench with the utmost seriousness. Of course we do. But may I say this, that
If it's the case, as Mr. Kent interjected, that it's referred to in Jeremson, that might mitigate what we're hearing, but we'll see that in a minute when we get to Jeremson,
yes.
if it is a minute.
Yes. What I was going to say was that, of course, what is to be derived from the documents is a matter of law. And even if my lord was dissatisfied with precisely how matters were put below, I certainly can't criticise the learned judge for not referring to a document that he was not directly referred to, but of course there is the reference in Jeremson.
Is it a matter of law? I mean, coming to this relatively cold, I'm struck by how law and fact seem to get a bit confused in this area. But in principle, one would think, well, law sets the standard, and then you look at the facts in each case to work out whether that standard has been failed to be complied with.
Yes, my lord, if I may say, is an entirely fair observation. The peculiarity of this area of litigation is that, as I said right at the beginning, there is an accretion of accepted interpretations of what should have been known, drawn from the documents. And that we respectfully say, Lady Justice Hale, as she then was, tells us is a matter of law in Jeremson. What is to be taken from the documents is a matter of law. Because it's the
I'm not sure I agree
construction.
with that second. That sentence that she made or endorsed a finding of fact made in that case and said that that was capable of or did satisfy the necessary test,
Yeah.
legal test.
Yes, but she does say, and we'll get to it, I promise. But she does say that what is to be taken from the documents is a matter of law because it.
Okay, well let's wait. Let's wait
Yes.
till we get. Let's wait till we get.
I'm sorry, I'm just going to turn my back 1 second.
But if I may say so, a related point, but drawing on what you've just said, if, and I'd certainly get this impression, there are one or two key cases in the authorities, Jeremson being the most important, Abraham's being another, though I appreciate only first instance, which conduct an elaborate review of the literature and draw certain conclusions from it, which certainly in the case of Jeremson, if not binding, will be highly persuasive. To what extent does it help us to do what you have been doing, going through all the primary documents on which those conclusions were reached?
What
Well,
you're trying to persuade us is that it should now be where for many, many years it has been accepted wisdom that people had no idea that light, I'm using the soft language, light exposure, even with occasional spikes in it, did not give rise to a foreseeable risk of injury. You are trying to very skillfully persuade us that that is an error, and that from 1932 any reasonable employer should have realised that as soon as you had a cloud of dust, you should have been taking steps. You were negligent if you didn't prevent it.
My lord, I wouldn't characterise it like that. May I characterise it?
I'm deliberately putting it quite tendentiously, but you are coming pretty close to it.
Well, with respect, I hope I'm not. What I'm seeking to do is to invite this court, having looked for itself at the documents that have been underpinned on several occasions, and nobody suggested, for instance, in Maguire, that the Court of Appeal, this court, should not have looked at the documents again, even though they'd been assayed in Jeremson. What we are seeking is to say that now that it has arisen on the facts of this case, that the Mr. Archer put expressly that visible dust was the marker, that this judge didn't really deal with that argument, that we press it upon this court with respect in this case, that this court is tasked to say whether or not the visible cloud of dust is the marker. Now we may fail on that, in which case this appeal will be determined against us. But it's not an unfair or repetitious exercise, nor is it revolutionary. It's just nobody's asked the court before.
I haven't seen anything so far in what you've shown us that says visible dust is the marker.
It starts with Mr. Matchell in Jeremson.
Mr. Matey is a judge, not an expert.
I think my lord
I'm so sorry, as to the evidence below. Yes.
No, you've been taking us through the evidence.
Yes.
I mean effectively the literature. I found nothing in the literature so far that says visible dust is the marker, but I appreciate we've only looked at 2 papers so far.
Yes. No,
But I haven't seen it referred to anywhere else either.
The visible dust test is used by Mr. Matchell as the last resort, effectively,
Yes, I see.
because there's no way of measuring.
Yes,
and there's no
okay.
guidance at the
But
time.
let's keep going.
Before I do, may I just please? I've had a note from Mr. Archer saying as follows: that the reference to the 1933 tubercle article is paragraph 45 of Jeremson. He did take the learned judge to it.
He took it to paragraph 45 of
To
Jeremson.
paragraph.
Yeah, okay. Well, that may be a complete answer, but thank you.
Thank you. I'm going to move on now with great rapidity.
Just one more point while we're interrupting you. If we have got, I haven't focused on were there skeleton arguments below?
Yes.
But it's a short hearing, of course. So skeletons, presumably before the hearing, but not again on day 2 after the evidence.
My understanding is that it would have been oral submissions. I can turn my
Yes, no, that's fine. I just wanted to be sure.
Yeah. And one can see that there's from the transcript. It's a very iterative process between the learned judge and counsel, as it should be.
As it should be. Yes.
Yep.
Can I just?
Yes, of course.
Michael, I'm not sure whether you've read page 1961, top second paragraph, in particular. Right hand.
Yep.
I'm so sorry. I'm just,
111 in 1961, previous page.
yes. Learned from Mr. Kent asks me just to read to you again from the tubercle document. Page 1961 at the bottom, internal page 111. The first full paragraph. Yeah, on the right-hand column. Yes, thank you. Particulars of cases seem to show that with high concentrations of dust, the minimum period of time which must elapse between the commencement of exposure and the production of a serious degree of asbestosis is approximately 7 years. which include not only the trapping period of the fibrosis producing dose of dust, but also the maturation period of the fibrosis, which periods, of course, overlap.
Was that 1962?
61.
61. And then, yeah, top right. A final passage from this document before we can move on very quickly is at page 1964, left-hand division.
Is this something that Mr. Kent has asked you to refer us to, or is it something part of your submissions?
It's my submission rather
Yeah,
than
okay.
his.
Yeah.
Which page?
This is the left-hand division,
Yeah.
page 116, which just sets out in the first paragraph that there is not a necessary correlation between the presence of very frank and very serious asbestosis and health compromise, because it goes through again that the general burden that fibrosis puts on the bodily system
Yeah.
can render the person somewhat vulnerable. In that case, and now moving on quickly, we've referred on a number of occasions to the factory inspector's report from 1938. Can I give the reference because it's there to be read? But it's in the supplementary bundle, the second supplementary bundle from Cuthbert, divider 14 at page 89. And then at page 90,
Sorry, second supplementary bundle.
page 89.
Thank you.
It's at the top of the page is the statement setting out why section 47 is considered to be such a boon. Perhaps I can read just the 10 lines down. There can be no doubt that dust, if inhaled, is physiologically undesirable. Moreover, dust that is thought today to be harmless may follow in research be viewed in another light tomorrow. It is not many years ago when the dust of asbestos was regarded as innocuous, whilst today it's regarded as highly dangerous. And then if you turn the page over to page 90, this is a discontinuous page within the same report, but it deals with asbestosis and its association with cancer of the lung. So the point to be taken from this is that as early as 1938, asbestosis was being considered in some way connected with lung cancer.
So,
Forgive me.
so
It is yet another risk that is foreseeable for exposure, for arising from exposure. And what is not known, we know expressly from this paragraph here, is that nobody understands the connection. Nobody understands whether it's dose-related, whether asbestosis is protective against lung cancer, merely that there is some signal. And so the so, my lord, is that we're seeing cancer for the first time referred to.
Okay.
There is then at divider 12, the annual
Part of the
report.
same bundle.
It is. Yeah, this is all the second one. Divider 12, page 93. I'm so sorry, that is a wrong reference. It is, yeah, I'm wrong. It's divider 15, I'm so sorry.
All right.
The 1943 report. Which is the one which refers to one fatal case of asbestosis, which might have occurred after an employment of 0.5 years. And it's this document that is often referred to as whether that was the rogue 0.5 years.
where do you see that?
just lost the reference, forgive me.
Page 93.
Page 93, yes, and it's halfway down.
Under asbestosis.
Sorry, I'm behind you. Just tell us.
It's the shortest, can you see that the table has duration of employment in years?
Yes.
Longest, shortest, average,
Yes.
asbestosis, this is fatals, and you can see it's 0.5 years.
So this is a case of asbestosis identified after half a year's
Yes,
employment,
leading to death.
leading to death.
Yes,
Particulars refer to fatal cases, yes.
yes. There is then at divider 16.
So that would be diagnosis. Half a year's exposure. So it's a fatal case of asbestosis where the exposure was half a year's employment.
Yes.
Okay.
That
Thank
is on its face. It has often been questioned as to whether that is just a rogue figure, but there it lies. Divider 16, if I may, my lords. This is the report of the Chief Inspector of Factories in 1949. And the import, this appears at page 99 of this document. Is twofold, and it's the bottom left-hand side of the page, the asbestos regulations. There are two things to be taken from this, we say. The first is the emphasis on the maintenance of dust control. And second is the emphasis that asbestos can kill in asbestos can cause disease in unusual circumstances, because 5 lines from the bottom we see the following, and from the inspection point of view, it is very necessary to keep an ever watchful eye for the new use of asbestos in some manufacturing or other process. And it goes on to say, for example, on ships or buildings, where the work may be undertaken by someone not fully realising the necessity of preventing as far as possible the inhalation of asbestos fibre and dust. And we see the phrase prevention as far as possible. There is then,
Well, I see the time.
yes,
A very short reference will be fine, but if you're embarking on anything substantial, we'll.
no, two headlines, and then
Okay.
I've reached the end of the documents. The first is divider 18, page 107. Warning from a standard work, factory health, safety and welfare. No effort is wasted in reducing asbestos exposure. And then finally,
So which page?
this is page 107, I'm so sorry.
And where's the reference you're reading? That's a quote. Is it no effort?
Yeah, it's 108, forgive me, I'm so sorry. On the left-hand side under the title asbestosis.
Yes.
And then finally,
Yes,
Chief-
I haven't found.
oh, I'm sorry.
What is there some? You said something about no effort is. I
Yes.
haven't found that
It's,
yet.
it's just a no degree of care.
Yes,
Oh, I see.
yes, my fault, I'm so sorry.
No degree of care is wasted. Okay, I've got that. Thank you.
Thank you.
Yep.
And then finally, divider 19, page 112, the 1958 Inspector's Report at 119. Bottom of the page, asbestos. Again raises the relationship between asbestosis and lung cancer. Well, Lords, thank you for your patience. That ends our review of the literature.
Right. Now, being realistic, how much longer are you going to need?
Well, my Lords have clearly read the judgments. I need to go to Jeremson at first instance. I need to go to, with your permission, Owen and IMI to make good the propositions that the exposures were not terribly different to the ones here.
Well, that's a first instance case. that's just a factual conclusion, is that? Do we need? That's Miss Justice Buxton's case,
It is.
right? Okay.
But of course, it is central to the thinking that you only reduce
All
the
right.
lowest.
I don't argue about it at the moment. I just want to get a picture to see whether we ought to be concerned about time. I'm not terribly concerned because I thought that your division at the beginning was pretty ungenerous to you and pretty generous to respondents who have less work to do because they don't have to take us through all the literature again. So perhaps we can just leave it that although I said you needn't keep your eye on the clock, I think you're going to begin to need to. But I do appreciate that lots of the stuff you'll be taking us to, we won't have to be taken to a second time round. So
Could I ask indulgence for 45 minutes after lunch? And,
certainly, I think there'll be no problem about that.
Thank you. I will.
Okay.
Don't make any promises.
I've obviously experienced my advocacy before.
2 o'clock.
Thank you.